morning, Mr. Tanner.
May it please the Court. There are two housekeeping matters arising out of yesterday. The first is that we prepared the list of the references that you asked for yesterday. I don't know if a copy of that is now in front of you.
No. It won't surprise you to know, Mr. Tanner, that I won't be looking at it on paper. So
Right.
it will be necessary to send it to me electronically.
We'll do that. In that case, I'll just describe what it is. We set out on a single sheet the references, as you asked for. We give the internal bundle references as well as the page numbers in the bundle. And then, over the page, very shortly, there are additional references for other parts of the cross-examination that I mentioned yesterday and which I'm going to take you to today.
Okay, lovely. Thank you very much. I assume I'll get it pretty quickly, right?
And behind that, there's the PDFs of the original documents you wanted as well.
Yeah. Oh, great. Thank you.
Okay. So that's the first. The second is that we reflected overnight on the observations which you made, my Lord, at the end of yesterday's hearing. And we consider that you are right.
Good.
Yeah, well, the fact is that
It's unusual.
Yeah. No, not at all.
Have you asked the Supreme Court?
The H2 judgment, as we were saying at the end of yesterday, wasn't accompanied by a formal order, but it does make what amounts to dispositive provisions in the concluding paragraphs. Right. We see that, and that they serve the purpose of an order.
Is that H2?
It's H2. May I invite the Court, please, to reopen H2, because we thought about what you said, and these are our conclusions of what we've done about it. So you go to page 488. 488. 488. Right at the back, core bundle 1, 10B.
Para
157. If you have that open, actually, I'm sorry, I'm going to give you one reference before that. The section before that is called Conclusions Regarding the Grounds of Appeal.
Yes.
It's interesting because it's expressed as the conclusions. And you see paragraph 154, which I mentioned yesterday, but you see it under the heading now with your Lordship's insight into this. For the reasons we have given, we uphold the findings of cartel infringement. And one way of reading that is, as we did originally, that is a definitive conclusion. It is, after all, put under the heading Conclusions Regarding the Grounds of Appeal. But then if I can go forward to, as I say, 157, the heading here is questions of due process. It follows conclusions. And you need to see how they do it. 1571, you have the conclusions that the CMA's decision depended on the findings of sham and intention in particular, the two limbs of dishonesty. And you see they hold in the last sentence, we have affirmed those findings for the reasons given in this judgment. Now, on the basis that that is a final conclusion, and taking your Lordship's steer on this, we agree. That is a conclusion that we challenge and disagree with for all the reasons that I've developed. If you then go on, in 1572, you have the concern that the dishonesty case was not put fully to the advance witnesses by CMA's counsel at the trial, not fully put. Then at 1573, page 489, the tribunal states that the CMA has made a decision which it considers on the merits, last few lines, to have been correct. Had Mr. Sully and Mr. Baton not been called, last sentence, we are entirely satisfied the appeals ought to be dismissed for the reasons we've given. Yep. After that, in the next two paragraphs in particular, the tribunal gives directions. So these are operative directions as opposed to, as it were, declaratory statements. And again, we take the Master Roll's point that these can and should be treated as serving the purpose of a dispositive order by the tribunal. you'll see that the tribunal directs, in particular, 1581, that the judgment should be treated as closed. But then the important one for us, it declines in 1582, declines to finally determine the appeals, and 159, and it says that the appeals should be restored for further argument so that they can be finally determined. So we understand the perspective, and if you look at it in this way, you treat these as being essentially the operative terms that in an ordinary appeal would be the subject matter of the appeal the order, not the reasons in the judgment. This would be the subject matter. Now, what does one do? As the court's aware, well aware, we firmly contend that the tribunal erred in declining to dismiss the appeals finally in the H2 judgment, because our case is that all of the findings and the reasoning about the need to show dishonesty, which is the centrepiece of this judgment, were wrong. How does that now come before this court? Well, the issue of dishonesty is already central to the CMA's appeal against the H3 judgment, and our skeleton dealt with that in the first appeal. It is also central to the company's respective appeals against H2, which they made following the first case management hearing before this court. All four of their appeals are squarely based on the dishonesty point, but their perspective is dishonesty is an essential part of the case, and the CMA failed to deliver by proving, by failing to put dishonesty to the witness and failing to make good a case involving dishonesty is how they approach it. And if I may just show you that, you go to...
As I understand, so the cases, as I understand it, might be oversimplifying. It's not that it's necessarily part of the law, but it was part of the CMA's case and therefore has to be addressed. And a failure to address it properly should lead to vitiation of the decision. But they don't say it is an essential part of the law.
That's right. That's right. Absolutely. And that's very clear. If I can just give you the references, it'll take a minute. In that core bundle, volume 1, you can walk through them. You have the skeletons. You have Allergan's at tab 4. If you go in core bundle 1 to page 78. Paragraph 3.4, and this confirms what my Lord Justice Green was saying. So Allergan says, dishonesty is not a necessary element of the finding of infringement of competition law. Nonetheless, it was, insofar as relevant, a necessary element of the finding of infringement set out in the decision in this case. That follows from the nature of the infringement alleged. They refer to the sham, masking, and unlawful underlying arrangement. Alternatively, the decision rested on a series of findings that were akin to findings of dishonesty. And they say in the last sentence, the critical point is that the CMA was obliged to put all the critical elements of the case to the witnesses.
Yes, my learned friend skipped over the sentence before that, which is also important.
Well, leaving aside the skipping over, let's read that then. Whether or not the decision rested on a formal finding of dishonesty is of secondary importance. And then the critical point is that the CMA was obliged to put all the critical elements of its case. So you see, exactly as Lord Green said, that is how they deal with dishonesty.
So this is Allergan.
This is Allergan, and I can give you further references, but if you go just perhaps to two of them, you go to page 92 in Allergan. Paragraph 36.
Do we need more than 3.4?
Yes, it's internal page 18, page 92 of the bundle, paragraph 36 near the top, last 4 lines. However, in this case, the CMA were rightly and inevitably given the findings in the decision alleging a finding of intentional infringement. It was obvious from the moment the decision was published that the CMA's case came close to or involved an allegation of dishonesty.
So I'm not sure where you're reading. 32?
No, my mistake. it's 36,
36, thank you.
which is at the top of bundle page 92.
Got it.
And equally, one more reference, just to make it absolutely clear, page 106 in Allergan, paragraph 87. So that's top of the page, 106. Third, insofar as necessary, the CMA's failure to put that case was particularly unfair because the findings in the decision rested on an allegation of dishonesty or impropriety, what at one stage the tribunal president referred to as naughtiness. So that's how Allergan introduced the case. And
I'm sorry, I haven't got the paragraph number.
87.
87.
87.
87.
it's my,
It's page 105.
Yeah, no, I've got it. Thank you.
I have page 106.
Got it. Thank you.
We can
Problem
agree
is
it's
that someone
somewhere over
substituted
100.
another version of the skeleton argument the day before yesterday, which didn't have any page numbers other than the internal page numbers.
I understand.
One of the infuriating aspects of what was going on earlier in the week.
I'm sorry, I was unaware of that. So that's the first of the four. Advance in the next tab, 5. It's in various places. But if you go, for example, to what is paragraph 75, which in my bundle is on page 155. You'll see that at the bottom of the page. It's the written agreements themselves. The decision stated they were a sham. The advanced employees lacked any bona fide or genuine intent in concluding them. And then the reliance on Snook for what a sham means. So that's paragraph 75 at the foot of the page. And if you just look up at the preceding two paragraphs, 73 is the difficulty is that the CMA did make very serious allegations of dishonesty or serious misconduct in the decision. And at 74, as the correspondence with this is the Pinson Mason solicitors, you'll see halfway down, this is none other than an express allegation of deceit. It's alleging that advanced employees involved in communicating with Pinson Masons knew about the separate pay for delay understanding and misled their solicitors into believing that Advance wanted its supply arrangements to be competition law compliant when they desired no such thing. It would mean the conversation on the call on 6th of June was false and wholly misleading. It would mean the solicitor who recorded the agreed terms was duped. So they very powerfully put a case of dishonesty in those ways. The third is Sinvan in the next tab, 6. In my bundle, this is page 195, and I'm looking at paragraph 61. That's halfway down the page, internal page 29 in mine. The second sentence, in Sinvan's submission, however, the tribunal was quite right to say that although dishonesty is not a necessary ingredient of the Chapter 1 prohibition, these issues of dishonesty were so inextricably linked to the findings that were made in the authority's decision that the authority's case on infringement would need to be put with some clarity to any witness. And the last of them is Auden in the next tab.
Can we look at 64.3, please?
Very happy to do that.
Page 197.
54.
64.3.
I'm not sure, perhaps Mr.
Well, perhaps it can be dealt with later. You just
So-
give us some reference.
And particularly given the need to complete my submissions.
Yeah.
The last one is Auden in tab 7 at paragraph 47, which in my bundle is at page 229. And you'll see it's convergent with the others. The proper cross-examination of witnesses requires the putting of one's case. That obligation is, of course, especially important where what is being put is fraud or dishonesty. Auden relies on the submissions of the other parties in this regard, doesn't repeat them. refers also to the law, and also
Did Auden call any witnesses?
they didn't know.
Yeah.
They did not. And that's so Mr. Patel, who was their negotiator.
So Sinbin called Mr. Stewart. He called Mr. Stewart.
Allergan,
Allergan called Mr. Stewart. Advance called the two main witnesses we've been talking about. Did Sinbin call a witness?
Miss Lifton was called by Advance as well.
Yeah, yes.
Mr.
Sorry.
Middleton.
I'm talking about internal witnesses.
Yes.
Auden didn't call any witnesses.
No. And Advance did not call Mr. McEwen, who was the negotiator prior to Mr. Bacon coming in. So then, finally, to complete it, on Auden, paragraph 77, which in my bundle is 239, page 239, halfway down the page. You'll see there 77 to 77.1. That is so because necessary questions underlying the tribunal's factual conclusions were not put to the witnesses and were not otherwise explored at trial. The necessary questions concerned, first of those, not only allegations of wrongdoing and dishonesty. And pausing there, the point is that all of them, in convergent ways, rely on dishonesty being a part of the CMA's case in this decision, the tribunal finding this to be the case, CMA then not properly putting the case at the trial. The CMA's position responding to all of this was set out in our recent skeleton argument on the 26th of June on the H2 judgment, and I'll just remind you of that. It's in tab 9 of the first bundle, the core bundle, and we deal with it extensively here, but the relevant parts are paragraph 28 under the heading dishonesty, page 273, I hope, in the court's bundle. And we say the company's appeals require the topic of dishonesty be addressed in greater detail. And from there all the way through, I won't take through the detail because I amplified it in all submissions, to paragraph 38 on page 277, we dealt with that. And there is a further paragraph which is on page 281 under the heading dishonesty at paragraph 54. The procedural route, now to come to where we are, the procedural route which we follow to date, as the court knows, has been to say that by way of the respondent's notice, the finding of dishonesty was not a necessary part of the tribunal's H2 judgment. It could have been affirmed on different or additional grounds. Essentially, it should be upheld on the basis of the reasoning in it that I've taken the court to, which stands independently in our submission from the issues of dishonesty and which reflects the core findings in the CMA's decision. That appeared to us to be the correct route, given that the CMA does not want to appeal the trenchant findings in H2 under the heading conclusions that the company's grounds of appeal against the authority's decision all fail. But in the light of the Master of the Rolls' helpful intervention yesterday, we do agree that in the unusual circumstances of this case, the appropriate route may be for the CMA to make clear by way of our own appeal, as the Master of the Rolls suggested, that we consider that the conclusions I've taken you to in the last few paragraphs, 157 to 160, declining to finally determine the appeals, which you can see as a form of final order, that conclusion is an operative matter that should not stand in any event. Excellent. That conclusion, or that direction, should be set aside, and this court should make the order that the company's appeals fall to be dismissed in the place of the tribunal. Now, I apologise for the delay, but literally just come through the door. Reflecting exactly what I've said, we have prepared appellant's notices with grounds, which I can hand out, and you can look at now, and I'll hand to my friends as well. They have got them. So this is a concise notice of appeal, and we will need to seek permission.
I think you need one more for Mr. Jowl.
I can't give mine. Is it possible to share? Right, sorry. So here, there's only two parts you need to look at. To assure yourselves that they don't go beyond what I have said. And those are, at the very end, the grounds of appeal. It's the last 2 pages.
Yeah.
And if you cast your eye over that, it should reflect what I have said to you today and what I submitted to the court yesterday and what is in our skeleton argument, which you
And
also
you
just seen.
will need permission to file that at a time.
I'm very much obliged.
Well, we'll have to hear what the other side say about it, but I think the best idea is to let them do that in the course of submissions rather than dealing with it now.
I'm very much obliged.
And you'll send it to me electronically.
We will do that. All I would say, my lord, is the point which follows from me taking you through their cases, that there's no prejudice because all of these points are already in play and in dispute. But there is one particular consequence of us regarding the case in this way. You'll recall that ground 1 of our appeal was that the tribunal reached a definitive conclusion in H2 that the grounds of appeal should that the grounds of appeal fail and that their appeal should be dismissed. That was under the conclusion section at the end of the judgment. And our case was that in view of their operative finding there, it was then inconsistent for them to go on and do what they did, which is to start to investigate the dishonesty point. And they should have stopped at that point because that was their operative conclusion. And we looked at that paragraph in that way. Our ground, therefore, was based on the premise, that ground, that the tribunal in H2 did reach a final decision because it expresses itself in unqualified terms. And now what I'm saying is therefore a change because we say, in the light of the debate yesterday, that the correct procedural approach is to appeal against those parts of the concluding paragraphs following on from that onto the due process heading, which are operative, with a decline.
You're jolly lucky, aren't you, Mr. Turner, that we allowed the respondents to bring their permission to appeal applications in relation to H2 so that it's all in the mix before us. Otherwise, they might have a real case against you on this. But anyway,
No,
we'll hear what they say.
no, my lord, yes, and we're grateful. But that is now what we're doing, which
You
is
might be grateful.
You might be grateful.
we might be grateful. We're not clear whether we will be grateful.
No.
Yes. So with that,
Anyway, I'm very grateful to you for having considered it so carefully. I think it was a real point, and you've obviously grasped that real point.
well, we're grateful too because I confess that we hadn't looked at it in quite that way.
Thank you.
Then, if I may, I'm going to resume my submissions on the H3 judgment. I'm going to go at quite a brisk pace. I hope the court will bear with me, but please do say if there are any points at which we need to enter a debate. So we return to the judgment, which is at tab 10A in the core bundle. I told you yesterday that I was going to make good 3 points. And the first was the point that the tribunal's focus moves away from dishonesty, which was the major focus of the H2 judgment, to a supposed failure to put the existence of the understanding to stay out of the market to advance as witnesses. And to frame that, if I may, I want to show you just one paragraph in H2 that I didn't emphasise yesterday.
You said there were 3 points. Could you just give me those 3 points? Because although you gave them to me yesterday, I'm not quite sure I've got them in the right place. You said that you were going to make 3 points about this judgment. One,
Yes.
the move from dishonesty to failure to put. 2,
Yeah. The first is that the second is that they misunderstood the CMA's case in this judgment in ways that didn't even reflect how they characterised it in H2. And the third is something that I've already trailed, that they misunderstood the cross-examination by Mr. Mitriou of what it comprised and the answers given by the witness, which are the gist of the reasoning leading to their final decision that they can't stand.
You're going to come on to that.
I'm taking them in turn.
Okay.
So on this first point, which I was on yesterday, there is one paragraph in H2 that I didn't focus on that I wanted to show you because it is extremely clear, and that is on page 486 of the bundle, paragraph 153. Sorry, my note seems wrong. It is.
there isn't a 153.
There's a 153 in H2, there's none in H3.
Am I in the right?
We're in H3, aren't we?
You said there's another paragraph of 8.
Yes, hold on.
H2.
Yes, got it. Sorry. The note is correct. So at 153 of H2, the introduction, you'll see at the top, this judgment raises questions of dishonesty.
Yeah.
And then 153.2 below, Roman 1. Here what I want to do is pick up on the remark made by Lord Justice Green yesterday about the difference in their treatment of dishonesty between the undertakings and the individuals and how they approached it, because I hadn't done so yesterday. So you'll see in 153.2.1, we consider that as undertakings, without making any findings in regard to individuals, Auden, Waymaid and Amco behaved dishonestly in concluding the agreement. And they say that that's consistent with what the authority's decision found. Pause there. Lord Justice Green asked yesterday, well, how does one identify the source of that dishonesty without it being attributed to particular individuals acting on the company's behalf? But here, there's a very clear statement that the companies behaved dishonestly without making any findings in regard to individuals. So how does one understand that? Other than the subjective intention part of the CMA's decision, which the tribunal has set out fully a few pages back, talking about particular individuals who had a subjective intention, including Mr. Baton and others, which does refer to individuals, we confess that we are not sure what this means. We do not understand it.
But it perhaps has greatest resonance in relation to the first 20 months when the relevant witnesses didn't give evidence. There's no findings against them. In which case any concept of attribution of an individual to the undertaking is more elusive.
It is. And even in this later period, the statement here is that we're not saying anything about any individuals.
Yeah.
Just to show you the architecture of their findings on dishonesty, that's the first point.
Yeah.
Then, over the page...
I mean, it's important that they say this is consistent with what the decision itself found, which is why when we all went hunting into the decision to see what it actually said,
Yeah.
to see whether or not it did support a finding of dishonesty, or was referring to something else, which is, we were looking at those provisions yesterday.
Absolutely, and it's because of that sentence that we went back and thought, are they referring to that long extract which is set out in paragraph 133 of the judgment over a few pages in 10-point type, which covers subjective intentions, because it wasn't clear otherwise what would be covered. But at all events, one sees what they say about the undertakings in dishonesty there. Then if you turn the page to 487 and look at the top of that, at letter A, the consequence of our analysis and our conclusions is that Mr. Baton was dishonest at the time of the conclusion of the second agreement, and he lied about it in the witness box. Pause there. Those 2 points in our submission need to be separated. We have submitted there's no need to make a decision on whether Mr. Baton was dishonest at the time of the agreement. Discussed that yesterday. The tribunal was entitled to find that Mr. Baton was dishonest in the witness box. I showed you yesterday 2 parts of the H2 judgment where the tribunal made it clear that it firmly rejected his evidence. And you'll note again that those were footnote 136, page 451, and paragraph 78 on page 446. So in particular, Mr.
176.
136.
Footnote 136. That was the long footnote where they said. It's footnote 136 on page 451 of the bundle. It was underneath paragraph 84. And the point there, or the major point there, is Mr. Baton said, look, I didn't inquire as to what the other side were thinking when they offered me these extraordinary terms. And the tribunal says, well, we can't accept that evidence. We can't accept that you didn't think. That's not how business people negotiate with each other. That's the point there. Now, in relation to this finding that the witness lied in the box, as opposed to dishonesty at the time, the CMA did not invite the tribunal to find that the witness was lying. The CMA's counsel did not put to the witness, you are now lying. And the tribunal could perfectly well have rejected Mr. Baton's evidence, not accepting the evidence, without finding that he was a dishonest individual giving untrue evidence. In any case, what you see from the paragraphs I've taken you to is that fairly and squarely, the H2 judgment treats this case as one of dishonesty. That is the centrepiece of it. Now we go to H3.
The short point is the adjectives don't undermine the validity of the rejection of the evidence.
That's right, yes. It's an overlay which is not needed. So then if you go to
Well, it goes back to the point we discussed yesterday about the straw man, doesn't it? Because you could reach the same conclusion by saying Mr. Baton was giving evidence about something that happened years ago and had convinced himself about something that wasn't correct or was just mistaken.
Yes.
And all sorts of ways in which courts dress these things up. You don't actually have to go as it were, all out for the jugular and say this witness was lying.
We must find that the witness was lying.
Sometimes it happens, but it doesn't have to.
Yes, neither the nature of the case, this competition case, nor the nature of the evidence in our submission required that to be done. So now we are looking at the change in the H3 judgment. If you turn that up and go in the bundle to page 316, under paragraph 21, internal page 16, that was a footnote that I showed you at the foot of page 16, and you'll see that there, in relation to shams, which is referred to at the outset, 3 lines down, we do not consider this point to be relevant.
Sorry, I need to have the reference again.
No, it's a footnote 16
in the
in H3.
H3 judgment.
And it is,
Paragraph 21.
yes, it's underneath paragraph 21, internal page 16. I looked at this briefly yesterday, without reading it through again. This is where there is an important and very clear shift. We do not consider this point, which was the sham point, which the companies were pursuing as important, to be relevant. And now the point of concern is framed as the making of extremely serious findings, and in the last sentence, it's the failure to put the essential parts of the decision and the crux, that is the crux of the due process question, and it's to this that we now focus. The residue of dishonesty in H3, which remains, and it is only the residue, is the claim that the evidence given by Mr. Baton in the box at the trial needed to be challenged by the CMA's counsel as lies. And that I showed you yesterday. It's at paragraphs 131 and 133, internal page 84, page 384. And this, at 131, as you see, we consider that had the CMA put its case to Mr. Baton, essentially this is the counsel at the trial, it would inevitably have had to allege dishonesty on the part of Mr. Baton. And then 3 particulars are given of where dishonesty should have been put but was not. And our point on this is that the CMA's counsel did amply put the case to Mr. Baton. She didn't need to go on to accuse him of lying. The authority on this point, and forgive me if this is also basic, that we have relied on in our skeleton, is the Re B case and the judgment of Lord Justice Peter Jackson. I can take you to it or simply report the relevant extract. What he says is, the rule about putting challenges to witnesses, and this is paragraph 18.
Which tab?
I may as well take you to it. It's Authorities Bundle 3, tab 45, page 1814. This is Re B a Child, Lord Justice Peter Jackson, Lord Justice Newey and Lady Justice Appellant. If you go to page 1814, where you have paragraph 18, you have the red-lined part that we have relied on. And I'll take you to the key sentence, begins about 8 lines down after Phipps and on evidence, talking about the need to challenge witnesses. The rule is not an absolute one. There will be cases in which it will be pointless to make formal challenges to a witness who knows perfectly well that his or her evidence is disputed, and where the challenge could in reality go no further than, I put it to you that you are lying. And we say that the tribunal has erred here in essentially taking the position that the CMA's counsel failed fatally by putting to Mr. Baton, I put it to you that you are lying, and that was no necessary part of the case. Now, the tribunal brings to a head in H3 the altered reasoning on dishonesty at the top of page 385. You can put that up away, I'm sorry, return to the judgment. So we go back to H3, and you see a crystallisation of the altered reasoning at the top of page 385, internal page 85, paragraph, within paragraph 134. And I'd ask you to look at that, please, and read from the third line, which begins, establishing dishonesty, third line from the top, on the part of Mr. Baton, was not a necessary or essential part of the defence of the hydrocortisone decision. So that's actually what they are now saying in this judgment. That's very starkly different. What needed to be defended was the finding that the collateral understanding existed. That defence needed to deal with Mr. Baton's evidence that the collateral understanding, to his knowledge, did not exist, not least because AMCO intended, in complete contradiction to the understanding, to enter the market as soon as it could. That evidence had to be challenged. And now what you see is a reference to what needed to be put to Mr. Baton, had to be put to his assertion that they'd enter the market as soon as it could was untrue. It had to be put that his assertion of no collateral understanding at all was untrue. And below that, the tribunal says, find it difficult to envisage how such a cross-examination could have been conduct without making very serious allegations against Mr. Baton. But if such a course were possible, consistent with putting the defence fairly, we absolutely accept dishonesty did not have to be put. So here you see the change in focus.
Sorry, where does it say we accept?
This is just under the numbered paragraphs 1 and 2 on that page.
Oh yeah.
And I was reading the last 3 lines.
No, I got it. Yeah. Thank you.
So standing back, it's a very, very clear difference. The residue, as I say, is perhaps encapsulated in the use of the word untrue on 2 occasions, and the suggestion, therefore, that the CMA's counsel needed to put to the witness what you are saying is untrue, which is a loaded term, suggesting that you are essentially lying. That deals with the switch in focus. My second point is what I turn to now, and that's that in this H3 judgment, the tribunal presents an account of the case, the authority's case, which is incorrect, and even differs materially from the account it had earlier presented in the H2 judgment.
But if dishonesty is no longer an issue, then you go back to H2 and see what findings were made absent any concern about dishonesty.
Yes. Now, I have yesterday taken you through the findings absent any concern about dishonesty.
But you've just shown us the ultimate findings at the end of the judgment. So, absent dishonesty, those are their findings.
And indeed, the sentence, had Mr. Sully and Mr. Baton not been called, we are entirely satisfied that the appeal should be dismissed.
And of course, Mr. Baton gave evidence to the CMA under questioning.
Yes. Yes, no, absolutely. And
I'm just thinking of the logic of the structure of the way the reasoning's gone. If dishonesty is no longer the issue, are they just reopening the findings they've already made, or does one revert back to those findings?
yes.
I mean, bearing in mind it was provisional, but I mean...
Well, my lord, you make an important point, and this seems to connect with your the point you canvassed yesterday about looking at this from the point of view of public law as well. Because were it the case that the dishonesty point travelled through seamlessly into this H3 judgment, and if this judgment too was addressing the dishonesty concern, which had been surfaced in H2, then one might say, well, they went wrong at that initial point, and we need not concern ourselves with anything after that. They simply should have stopped there. It's a mistake. That is, of course, I would respectfully submit that this court can consider taking. Another way of viewing the problem is that in H3, precisely because there's now a different focus, there's been a fundamental failure of due process because the council failed to put the case on the collateral understanding. It's different, and I do need to address it on its own terms. And so that's how I'm approaching it. And in order to do that...
You say, and you're going to come on to this obviously, that the conclusion that they reached that Mr. Demetriou had not put the case about collateral understanding is just wrong.
Yes. That's the gist of what I'm now coming to.
And the summary of the cross-examination in the original skeleton argument, not the one that you're responsible for, the one that we prepared with the juniors and Miss Demetriou, where they actually set out very clearly what was put to Mr. Baton and what his answer was.
Yes.
I think it's paragraphs 30 and following of that original skeleton.
My lord, absolutely.
No.
And added to that already the 2 extracts from cross-examination
what you showed us
yesterday, where you saw the questions and you saw the answers from the witness. So I'm going to approach it in 2 stages. The first is to show you that in this judgment, what the tribunal presents is an account of the case which is incorrect. Because now, to describe it in a nutshell, the tribunal says, well, the only basis for the finding of a competition law infringement was an inference from this value transfer. On that footing, the tribunal seems to suggest it's very important when you have witnesses at the trial, if that's all there is, to put the case to them about the collateral understanding. It makes it more stark. And because one looks at the question whether there's been a fundamental failure of due process in context of the case at hand, this fact, as they now see it, that the CMA's decision rests on an inference from the value transfer alone, means that there is all the more a need to cross-examine the witness carefully, the way that we understand it. So, with that introduction, if I may show you the points, one observation at the outset, something I've already trailed, is that the case that the CMA was making is that there was not a written supply agreement and a separate covert side agreement with additional terms and a promise to stay off the market. And Ms. Dimitri explained that extremely clearly in her oral closing submissions. If I could just ask you to look at how she explained the CMA's case in closing to the tribunal.
Yep.
It's in the 5th supplemental volume. It's at tab 22, electronically and in hard copy, page 1927. And it's a very helpful... Yes, 1927. Now, the bundle numbering used to be 1914. It's been changed in mind to 1927. Internally, it's page 12 of the transcript. I don't know if you look at the top right corner.
So it's page 25 on mine. So does it start, so I'm going to come back to the point that?
No.
No.
What's the page?
In which case it is...
Internal page of the transcript?
Right, the internal page is page 12 at the top right.
It's
Page
page 1914.
1914 and still in our...
Okay, well in mine it's been updated to 1927.
Well, why people can't keep the same numbering, I don't know. And use A's and B's and so forth.
Yes.
Might have saved a lot of confusion.
And photocopying.
Right. Right, so this it begins at the top, have to meet a higher burden of proof.
Yes, from line 9,
Yeah.
President to Mr. Demetriou. I think the essence is very much the debate we had, Ms. Ford. If the agreement works on its face, the supply agreement, there aren't such unusual facts as to require us to move away from that, find the existence of additional terms which aren't reflected in the agreement. The substance of the debate we had with Ms. Ford is actually we'll stick with the honest explanation, not the you'll come to honesty in due course. And then Mr. Demetriou explains the CMA's case. I'll come on to honesty. We don't have to show dishonesty. Our case, just to be clear, is we're not alleging a separate dishonest rider or a separate dishonest side agreement. We're saying the premise, the commonly understood premise from the supply agreement, was that it was happening. The supply was being given on these terms on the basis that it was an alternative to AMCO coming on the market. That was understood by both parties. It's not a rider or an additional term. It's the context in which it was commonly understood by both sides. And then further down, beginning at line 16, our case is more modest, she says. It's still anti-competitive. It's more modest than that which the appellants have sought over the last 5 days to try and erect for us. Our case is the supply agreement was a supply agreement. Those were the terms, essential terms agreed, but both sides understood the premise for that was that AMCO wouldn't enter the market with its own product, and that is the CMA's case. So the tribunal is approaching it, as you've seen, in terms of the side agreement and dishonesty, and it's corrected very firmly by counsel. The second point where the tribunal gets the basis of the authority's case wrong concerns the evidential support on which the CMA relies, the point I trailed a few moments ago. You have seen that the CMA was crystal clear that it was relying on the totality of a body of evidence, including the background to the negotiations, powerful contemporaneous documents, and evidence of conduct, including the cancellation by AMCO of its own product development immediately after striking the written supply agreement. But the tribunal finds in this judgment, the due process judgment, that the CMA's case was ultimately only supported by an inference from the single fact of a value transfer affected by the terms of this supply contract. If you go to page if you go back in the core bundle to page 313, this is in H3, subparagraph 9, foot of that page, internal page 13,
Yeah.
subparagraph 9 within its paragraph 19, you'll see in the second sentence the existence of the collateral understanding was inferred from the value transfer. And then if you drop down to subparagraph 10, first sentence, the value transfer was the only basis for inferring the existence of the, what it calls, collateral understanding. The tribunal does say that the authority initially had one other string to its bow, which is the point you've seen in the decision that AMCO suspended the product development immediately after the supply agreement was concluded. And I regret to submit that it was unarguably confused about that and misunderstood the point. If you go to page 314 and look at the footnote, which is footnote 14, internal page 14, you'll see that the tribunal is citing the statement in the decision in which the CMA specifically finds that following the supply agreement, AMCO suspends its product development project. And then it goes on. It says it was to rebut this finding that the appellants adduced the evidence of Miss Lifton from Ithaca, an employee of the contract manufacturing company. So they say that's what she was there to do. Now if you go forward to page 346 and look at paragraph 64, at the foot of that page, internal page 46, and look at the second and third sentences, the hydrocortisone decision, as we have described, rests essentially on an inference from the value transfer. The CMA had the further point that AMCO stopped developing an alternative supply because of the collateral understanding, but Miss Lifton killed that point. Now that finding by the tribunal is not one that a tribunal could reasonably have made and involved a misunderstanding of the evidence. I've already shown the court the contemporaneous emails from AMCO itself, which are relied on in the decision by the authority, which talk unambiguously about AMCO's cancellation of the project and the business people giving their reasons for it. Miss Lifton, in her evidence, did not address that cancellation. She did not address it in her witness statement, and when the contemporaneous documents were put to her in her oral evidence, she said that she was not aware that the project had been suspended. She was questioned on it, and that is what she said. And if you go to the supplemental bundle, I'll show you Mr. Dimitriou's question here. Supplemental bundle 2, tab 8, and now it's in my bundle, page 860. I'm going to have to give you the yes, thank you. Page 122 of the internal numbering of the transcript at the top right.
857 in our bundle.
Right, in mine it's 860. And one reads from line 14 and the council's question. If we go to this document, it's an email to Mr. Ross in the contract manufacturing company from Mr. Carl Belk. You see that? 27th of June 2014. Just as a matter of timing, it came between two other emails which we've seen. And then she goes on from line 20. You can see there that what Mr. Belk is saying is, and then she reads it, "Dear David, with disappointment and regret, I must write to inform you that our hydrocortisone tablet project will be suspended in the UK territory." She reads the whole thing out, and you see lines 13 to 17 on the next page. "Please be assured the suspension of this project isn't a reflection of any dissatisfaction with ESICA, won't in any way affect our decision to work on new projects with ESICA in the future." Now if you go to internal page 124, after she's put the document, you look up at line 6. Counsel says, "So you don't mention the suspension of the project in your witness statement, Ms. Lifton. Did you know about it?" "No, I did not." "You didn't know it was suspended?" "No, I would have been over the moon. It would have been a relief. It would, I can assure you." So this is not killing the point. The witness says, "I didn't know about this." For completeness,
Your point is that the internal documents in themselves from AMCO talk about termination of the project.
they do
And all
repeat,
this witness is doing is saying, "Well, I didn't know anything about that."
they do repeatedly, but you see that,
So what point, isn't it, really?
so, well, what the tribunal says is that Miss Lifton killed this point.
Well, I don't understand that at all.
No. For completeness, the CMA's counsel also directly confronted Mr. Baton of AMCO with exactly the same point. If you stay in the same bundle and you go to what is in mine, page 596, let me give you the reference. Page 596, so that's internal page 75. You start from line 8. I don't know if you have that.
593 and ours.
Okay.
So can you, internal page?
Internal page 75.
Yeah.
And you begin at line 8 in Mr. Dimitriou's questioning. This is an email from Mr. Belt to Mr. Ross. It's the one we've just seen. She's now putting it to Mr. Baton. She reads it out. And then over the page, which in yours is probably 594, at lines 14, 17, she says, "You can see here the fact of the matter is that AMCO wrote to ESICA, did it not, to cancel the project?" Answer, "I can see that." He then says, "But maybe it was short term." And there's a final bit of questioning over the page, internal page 77, your bundle numbering probably 595. Beginning at line 2, the witness says, "So it could be that this was, I don't know, short-term suspended and then reactivated." Question, he's not saying short-term. He's saying it's possible if circumstances change, the project may be resurrected. And you're right to say that 3 batches were taken and so forth. She says from line 8, "You can see on the face of this that there's a letter being sent to ESICA to cancel the forward production of the product for the UK territory. Yes, yes." It's not really much more of it than that. But my point is that the tribunal's finding that
Let me just ask somebody to go outside and tell them to stop using this as a meeting room outside. Sorry, say that again, can you?
I'm sorry. So I've shown you the questioning that she's put on this also to Mr. Baton. He effectively, as you can see, is agreeing with this point. And Miss Dimitriou then continues. She also puts to Mr. Baton an email that I've shown you, which he wrote to the staff in his company, thanking them for their work on this project.
Yes.
And that's at, now, let's see if I can find it. So it should be, it's possibly page 600 in yours, it's 603 in mine. And I begin on that page, internal page 82, at line 13. The counsel puts that document to Mr. Baton, the witness, and where he had said, if you see from lines 17 and 18, him saying we are able to launch. And then over the page, internal page 83, if you look at line 8, she questions, "So when you say the product's ready to launch, I think we can assume you were telling the truth and you were being accurate with that." "Yes, I assume so."
Sorry, is that?
Page 83.
83. between 8 and 10.
Yes.
So he's put to him at page 79 internal, even though you say you don't remember it now, you were obviously at the time fully aware this project had been cancelled and the team would have felt demotivated. I definitely remember this, and I remember we made a decision to choose the Auden product over the Isika product. These guys have worked very hard on it. Blah, blah. Then you want to go to 83?
No, just to make sure you're on what is in mine, I think, page 80.
Well, internal 80.
Is it?
And now you want to go to internal 83.
Yes. No, so I was on internal 82
Yeah.
from line 13, where counsel puts to the witness what he said about having the launch-ready product, and on what is internal page 83, lines 8 to 11, she says, so you can assume you were telling the truth when you said it was ready to launch. And he says, yes, I assume so. And then she goes on, as you know, we've subsequently signed a deal with Auden, this is from his document, to source product from them, and therefore our product will not be launched in the UK. Pretty strong. And over the page at 84, she puts the question from line 5. I think you are recognising there, are you not, that you have chosen the supply agreement over the launch of your own product? And then a crucial answer, which really is the CMA's case, single word, yes.
Where's this?
Line 8
Page
on
84.
internal page 84. In answer to the question from counsel, I think you're recognising that the one is chosen over the launch of your product. The commercial rationale quickly evaporating into nothingness. You're not going to do both at the same time, are you? Not at this time. It continues. You say the reason for choosing the supply agreement is the skinny label issue. Yes. In other words, what you're saying is that it's easier commercially to sell the Auden product because it's full label than your product, which is skinny. Yes. Then the third point is making Guy Clark's point about the importance of having the product ready to launch. That's what you believed at the time, is it not, Mr. Baton? Last line 25. I believe that having our own product helped the negotiations to achieve a deal with Auden. So it's all there. She's putting the leveraging point. She's putting the point that they had a launch-ready product. She's putting points that are entirely inconsistent with the, as we will now see, the rationale of the tribunal in the H3 judgment, that a commercial rationale of Mr. Baton, that he was just going to go ahead and launch his own product, was incorrect. It's all...
Whether Mr. Baton was lying or telling the truth, what emerges from this sort of passage, if you like, from about 75 onwards through to 85, is Mr. Mitru putting to him the point that they had discontinued the supply from Isika, a reluctance on his part to really accept that and to say, well, it was all temporary. We were really going to Isika, and then she really takes him to some of the stuff that he wrote himself, and he's then constrained to accept that that is what was going on, and that they were using the Isika supply as the leverage.
Yes.
I mean, that's it.
Yes, it is.
None of that involves having to say, well, you're lying in the witness box.
No, it doesn't. The case is put, and at this point, that's quite right, because needing to put your lying in the witness box is referred to in this judgment.
Well, once he's accepted what he accepted 84 to 85, it would have been completely superfluous to say, well, you're lying, you've been lying about what you said previously. Because if you like putting it in colloquially, the point has been scored, hasn't it?
Yes, and therefore...
Combined with the paragraphs you showed us yesterday, what you have is a series of concessions, which individually and collectively you say are sufficient. As my lord says, you wouldn't then put to the witness, having made these concessions, you're a liar.
No, for the reason really succinctly put by Lord Justice Peter Jackson in that Reby case, superfluous to do this.
This is what witnesses often do, is what one knows from experience. They sometimes prevaricate in their answers until you suddenly present them with something they wrote themselves, which is irrefutable, and then they accept it. But that, when you're cross-examining somebody in that situation, you don't then have to say, oh, when you said that earlier on, though, you were lying because you've got the answer you want from the subsequent evidence.
Yes.
Yeah. Okay. Right. Thanks.
So, point one, the tribunal's here saying in this judgment, all there was for the CMA's case was an inference from the value transfer. I've shown you, you know that is wrong. Point two, they say that there was another point that Miss Lifton killed it. And you can see that that is essentially unreasonable as a finding. And third, there's a closely related point. If you go in the H3...
Where's your Lifton point in the notice of appeal?
Well, it's certainly in the skeleton. I believe it is in the notice of appeal. Yes. Certainly a major point in the skeleton. Sorry?
Well, it's ground 2B, isn't it? It's within ground
It is in
2B.
ground 2B.
The tribunal wrongly rejected CMA's reliance on the evidence following second written agreement.
Yes.
AMCO delivery report.
Yes, said that the point was killed. And then that's developed in the skeleton specifically by reference to Miss Lifton.
Yeah.
Grateful. So, third point, a closely related error. If you go in the judgment to page 353 of the core bundle,
Can we put the transcript away?
we can put the transcript away for the moment, yes. I'm going to be coming back to look at a couple of further points later, but please do put it away now. And go to the core bundle at page 353.
Yeah.
And here, I want to look at the bottom of the page at paragraph 81.2. You've now seen something on this in the extract from the cross-examination that we have just read. But the tribunal finds the assertion that the CMA found that AMCO believed it would imminently be in a position to enter the market at the time the second agreement was concluded contradicts the decision and is not a point the CMA can properly make. Now this too is, I'm afraid to submit, an unreasonable finding. I have just shown the court the contemporaneous evidence that AMCO believed it would imminently be able to enter the market, and Mr. Baton being confronted with that and accepting it under cross-examination. That was what we were just looking at. Particularly...
Sorry, can I just ask you the purpose of these submissions? This is a procedural fairness issue. You have to establish that the issue was properly raised by counsel. Do you have to establish that the answer was compelling in support of the case, or are you trying to do both?
Here, what I'm...
You're refuting...
I'm doing both, essentially, because I'm going to come on to the putting of the case as a third limb. Here, my focus is on the characterisation by the tribunal in this judgment of the CMA's decision. Because, as I say, here they say it all boiled down to an inference to one thing, an inference from a value transfer.
Yeah.
And because of that, counsel had to be jolly clear in putting the case to the witness, and she failed to do so.
So in one sense, your argument, I mean, you may for forensic or other reasons go further, but in one sense, your submission just simply has to focus upon what was put and how it was put. And one then has findings, but are you inviting us to make findings of fact about this? I mean, maybe it to be in response to the respondent's application for permission to appeal, but this is I'm not really expressing any view one way or another. I'm trying to get my head around what the relevance of these passages is. It's certainly, we can analyse the way in which it was put, what the issue was, what the response was, and then see whether or not it tracks back to the way the tribunal described it.
Yes, I understand.
I'm puzzled. I must confess to being slightly puzzled by this because, I mean, this point at the bottom of the page, 353, is also, I mean, it goes back, doesn't it, to what they say. They quote what the CMA had said in 81, further up the page. These are presumably the submissions that were made, is it? The qualifications, these are the 4 qualifications that they refer to.
Yes, to the tribunal
earlier in their judgment.
Yes.
And then, and at footnote 92, they make the same point, don't they? it wasn't consistent with the Hydrocortisone decision, and it was not a point the CMA could properly make. But I'm extremely positive about what they say then, that the decision said AMCO suspended its ASICA development of 10 milligram hydrocortisone tablets, etc. But that isn't inconsistent with them being imminently in a position to enter the market before the arrangement was continued.
No.
It just doesn't add up, does it?
Yes. If I may, I'll address that, and if I may return to what.
Sorry, I'm sorry.
No, So yes, it certainly does not contradict the decision. Quite the opposite is true. And if you have the decision there in the second core volume, you see it in the original at page 992.
Yeah.
And the relevant paragraphs, which I needn't read, are 6.286 on that page through to 6.288 on the following page, which begins further contemporaneous evidence confirms AMCO understood it had or was about to have market-ready stock. So there is no contradiction with the decision. On this point, the decision actually says that this is the case. So it's an incomprehensible finding, and you have just seen the CMA's counsel's cross-examination on the email from Mr. Baton thanking AMCO staff for bringing the project to the point where it was launch ready. Now, in answer to my Lord Justice Green's question, which is, how does this fit in? We do say that the findings that were made in the H2 judgment, which uphold the CMA's decision subject to due process and dismiss all the grounds of appeal, should be supported, because in that judgment, in the parts that I showed you, the tribunal covers the essential elements which align with the CMA's decision. Yep. Now, in these respects, and that is sufficient, in these respects, the tribunal is going off-piste and characterising the decision in ways that are not right. I'm pointing that out first because of the impact that has on the due process issue. The tribunal saying, well, look, all of this goes to show that there was a jolly good commercial rationale that AMCO had. Council fails to put this, and there was only this single basis for the CMA's decision. So that's why it should have been done. And so I'm unpicking the premise for the tribunal's argument to show why that should be dismantled.
Yes, you've got to address the case. First of all, due process in H2 was on one thing, dishonesty flowing from intention and sham. Then, on your case at least, the due process issue changed, and you're addressing whatever it is that the CAT was then addressing as due process.
Yes. And I'm explaining how its reasoning on due process was flawed because the premises were flawed. It is also the case that you can see, and I would not stop this court from finding, that the findings, as it were, of fact about what the CMA's decision were in this judgment are unarguably wrong.
Well, that finding at the bottom, in sub 2 at the bottom, page 353, that it was contradicted the decision. It's just contrary to 6286 and 6288.
And
6288
others.
in particular.
Yes, it is unarguably wrong. Fourth point, and lastly on this topic, the tribunal suggests in this H3 judgment that there was also no relevant history of dealings between Auden and AMCO about hydrocortisone to serve as the essential context for the written agreements. And you see this if you go to paragraph 78 of the H3 judgment, which you will find at the foot of page 351, internal page 51.
Yeah.
You read it. The point is made, the 10 milligram agreement preceded the first and second written agreements. It was there. This is correct, but irrelevant. It's now irrelevant. So far as Mr. Sully and Mr. Baton and AMCO were concerned, there was no agreement other than that expressed in the first and second written agreements, and they had to be challenged on this. The fact that there may or may not have been an anterior, purely oral agreement between Waymade, a predecessor company, and Auden is nothing to the point. You see that the tribunal is here completely forgetting that AMCO succeeded Waymade, October 2012, within a matter of days after the conclusion of the oral agreement with the 10 milligram tablet, and that their negotiator, Mr. McEwen, continued to operate the 10 milligram agreement for AMCO for more than a year after that. And indeed, on behalf of AMCO, not Waymade, he negotiated an increase in the supply from Auden from 2,000 packs a month to 6,000. That was January 2013. Importantly, when he was at Waymade, this same Mr. McEwen had been the negotiator of the 20 milligram agreement. And so this is difficult to understand in itself and in comparison with the previous judgment, because in the earlier judgment, the tribunal not only referred to this, but it firmly said, you may recall, that the 20 milligram agreement had the same essential purpose as the 10 milligram agreement, and its words were, it would be wrong to so narrowly pass a course of conduct as to leave relevant material out. Just give you the reference, it was in H2, it was subparagraph 4 within paragraph 134. But in the interest of time, unless you want, I won't take you to it. So you have a complete and odd change, because before they said, well, you do have to, we take into account in our reasoning, upholding what the CMA did, the history, and it would be wrong to leave out of account relevant material. Here, in this paragraph 78, no. The written agreement is the only show in town. Beforehand, there may have been an anterior, purely oral agreement between Auden and another party, but that's irrelevant. And that is a most startling and wrong approach. But what it does is explain to this court why you see the reasoning being funneled towards what will then become the fundamental failure in the tribunal's eyes of the CMA's counsel to put the case when you have stripped away all of these other supports, and when, according to the tribunal, all that is left is an inference from the value transfer. The CMA's counsel's failure in its eyes is all the more stark. So that's sufficient to show the court that in the due process judgment, the tribunal both fundamentally and inexplicably misstates the case. It presents the CMA's case as a shadow of what it was, but that is not the end of it. Because next, the tribunal gravely misrepresents the points that were put by Mr. Mitriou to Mr. Baton in cross-examination, and the evidence that was given by the witness at the trial. So we come now to this commercial rationale point. So far as his evidence is concerned, the tribunal says he put forward a coherent commercial rationale for doing the supply deal, and it was consistent with there being no understanding about AMCO staying out of the market. You go in the H3 judgment to page 340, internal page 40, and look in the middle of that page at subparagraph 2, Roman 2.
So which main paragraph is
So this is internal page 40,
49.
Yeah.
and then in it, subparagraph 2, Roman 2, about halfway down the page, just at the hole punch, if you have a hard copy.
This is a paragraph 49 of the judgment.
It is in paragraph 49. And if you see, it begins, the appellant's position was, Roman 2, there was no collateral understanding any sort. The written agreements represented a stopgap, intended to fill AMCO's temporary inability to manufacture and supply in the market its own 10 milligram tablets. Once AMCO was able to do so, it would, according to Mr. Baton and Mr. Sully, enter the market and seek to contest about half of it at a marginally lower price than that charged by Auden. In this way, AMCO would make far more money than under the first and second agreements. Thus, the basic premise of the collateral understanding that AMCO would stay out of the market was refuted. Then if you drop down to Roman 3, perhaps pick it up at the third line, AMCO would receive from Ithaca at this low supply price not 12,000 packs of tablets, but around 40,000, around half the market. The marginal, AMCO would therefore make much more money because although its profits in the marginal case would be more or less the same, that marginal profit would be multiplied by 12,000 under the agreements and by 40,000 under the hoped-for arrangement with Ithaca. On this basis, AMCO would want the agreements to run for as short a period as possible. So what the tribunal is doing here is setting out, this is the supposed innocent commercial rationale that the tribunal describes as having been Mr. Baton's evidence about his position when he negotiated this agreement. Now if you go forward to page 379, internal page 79, and if you just look at the foot of this page, subparagraph Roman 5.
Which paragraph?
I'm sorry, it's within paragraph 1212, but
121.
121.2. But it's subparagraph 2, but then subparagraph 5.
Yeah.
Mr. Baton's answer. That paragraph, yeah?
Yes. And here, from 4 lines down, Mr. Baton's answer, he did say a great deal about the irrationality of the collateral understanding alleged against AMCO. In this regard, his point was that once AMCO had a deliverable product, it would enter the market, hence no collateral understanding, and contest 50% of it at a slight discount to Auden's price. Auden would, without any collusion, see exactly what AMCO was doing. There would be no price war. Both Auden and AMCO would preserve their margins against the prevailing very high market price. So this is the tribunal spelling out the gist of what it considers Mr. Baton's evidence was before it of his state of mind. Go over the page, you look at subparagraph 4 in 121 subparagraph 2 at the top of the page, and just look at the last 2 sentences. Mr. Baton's rationalisation for AMCO's market entry, as soon as AMCO had product to supply, needed to be challenged if the CMA was ultimately to say that that evidence was not to be accepted. The CMA did not do so. So there you have the point that that's the fundamental failure of due process. You've seen the commercial rationalisation the man gave in the witness box that wasn't challenged. Points then crystallised on page 391 of the bundle, internal page 91, paragraph 145. And if you have that, I direct you to 145 subparagraph 3. Those assertions, this is the commercial rationale point, were not so inherently implausible as to be dismissed without examination. To the contrary, Mr. Baton's version of events, that it would have been in AMCO's interest to enter the market at the moment it could, and the second written agreement was no more than a stopgap, enabling AMCO to supply the market while they secured their own supply, is a coherent explanation of AMCO's conduct, which is inconsistent with the existence of the collateral understanding on which the decision rests. And then four, without cross-examination of this version of events, neither the CMA nor this tribunal can properly disbelieve them and hold against the appellants. The judgment is for this reason fatally undermined. So that's the case. The tribunal is, in my submission, unarguably wrong that this was actually the evidence given by Mr. Baton about his state of mind at the time of concluding the supply agreement. It is also unarguably wrong that the counsel, the CMA, failed to investigate with Mr. Baton in the box what his state of mind was, or failed to put to him that the common understanding between him and Auden was the supply agreement was going to be the alternative to their independent market entry. And with that, I invite you, please, to open up again the cross-examination of Mr. Baton. And I will hazard the supplemental bundle at tab 6. Tab 6 in my
So that's the first
tabulation. It's the first supplemental bundle volume. It begins in tab 6. And I'm going to go to what is in mine, paragraph, page 481. In yours, I'm going to hazard it could be page 478. But internally, it's page 166.
Yeah, 478.
Sorry. So,
It is 478.
just to introduce what I'm going to say, what you're going to see is that Mr. Baton did not say that market entry, aiming for his company to sell 40,000 packs a month, half the market, was his thinking at the time of concluding the supply agreement. Mr. Mitriou established with him in cross-examination with supreme clarity that when he realised there were risks because his product was skinny label, he viewed the supply agreement from Auden for the 12,000 packs a month as a more attractive alternative to the risks of competitive entry. And the President appears inexplicably to have missed this, as you will see, and to have based the H3 judgment, therefore, on a foundation that does not exist. So on the page that you've got open, if you begin at line 7, I'm going to read through to line 13 on the following page. Question from Council at line 7. Mr. Baton, the way a negotiation works is that there's give and take. Is it not? There's give and take in the negotiation. So Mr. Patel would have needed some advantage to agree to a threefold increase in the volumes. Answer. You know, it's a funny thing. My experience of working with Mr. Patel was that sometimes you just asked and he said yes. You know, and that it was not a classic negotiation where you're horse trading. Mr. Baton, I can understand that might be true of some things, but here he was giving away a huge amount of his profit to AMCO. Answer. As I've said before, it's not something I would have done. Question. He's not a man that had some kind of death wish, was he? I mean, he was an intelligent man with experience in the industry. It's interesting because if you look at it, you use the word death wish, which is a bit extreme. But if you look at this thing, and if what the CMA is asserting is that somehow we've gone into some pay for delay discussion, pause there, witness appreciating the case against him, it really kind of does not make sense to me or to him, because he's supplying me with 6,000 packs per month for a bridging period, and as Council rightly says, he's effectively losing the money himself. But I'm developing and getting ready to launch my competitive product, which won't be 6,000 packs. It will be, the market I think was something like 80,000. So I would have been able to launch 40,000. So the whole premise of this case just doesn't make sense. Why would I accept any delay to my product for this measly amount of stock? What's in his head, I really do not know. So here you have, it is true, the commercial rationale, as the tribunal sees it in the judgment, stated by the witness at this very early point in the cross-examination. I can come in after a bridging period and I can clean up by selling 40,000 packs a month. Now you see how things developed, because it didn't stay there. You have to go into the second supplemental bundle for the continuation of the cross-examination. Day 3. In this second bundle, my copy is page 526. Yours may be 523, but it's internal page 5. I hope you have that. Internal page 5. It starts pick up the questioning at line 9. I've asked Carl, she reads, what are I'll get that on the previous page, from line 19. Council refers to this being an email from Mr. Baton to Mr. Clark on the 19th of April. And that's one of the documents that I took the tribunal to yesterday. And she reads from line 9 on internal page 5. I've asked Carl what our ESOCA cost and volume expectations are, and I'd say that if AMIC could get close to them, it would be worth having a long-term supply agreement with him. I'm also not keen on having a fight over the status, orphan status, or indeed having customers that see our product as risky. That last bit's somewhat risky as a reference to the skinny label, yes? Yes, that's right. And he goes on, pick it up from line 21. I think we were at that stage understanding that there was a significant part of the market that was not covered by our product. So now he's saying, later on, I came to appreciate this problem because we only had the skinny label product. Go forward 2 pages to internal page 7. My page 528, possibly yours 525.
Yeah.
At the top, lines 2 to 4 particularly, I'm not reading this extensively. The witness refers to the fact, this is the witness, the fact that our product was limited in its uses, so it was actually starting to become more attractive to me to try and do a deal with him. And then if you drop down to lines 12 and read to lines 21, question, you understood the risks of your own product versus the supply agreement, yes? Yes. You understood, I think, we can see from this email, you understood Mr. Patel's perspective was either he gets into a battle with you about the orphan drug designation if you launch, or he might offer you better supply terms than that. Answer, I was hoping, always hoping, he would offer better supply terms to me. He is confirming that a deal with Auden is starting to look more attractive and that cooperation is looking more attractive than the risks of competition. And then over the page, internal page 8, bundle page either 526 or 529, you have lines 6 to 11. You say, the question, that we're looking for Auden Mackenzie to supply Hydrocortisone to AMCO for a new 3-year term at a supply price of £1 a pack. I suggest we use the previous contract as the basis for this agreement. We are currently forecasting 12,000 packs a month. So he's saying to the person on the other side of the table, if we come in independently, it's the 12,000 that we will be launching. And the questioner is therefore recording him asking for the supply in the context of his own commercial forecast of what he would do. She confirms then with the witness in very stark terms the implication of what he is saying, namely that he wants the supply from Auden of at least the same number he could sell with his own product. You go to page 538 in mine, 535 in yours possibly, or internal page 17.
Yeah.
You'll see, if I pick it up at line 17 for speed, question, you specified 12,000 packs because that was your estimate of the sales you would achieve with the Isica product, or rather your estimate for the Isica product was 10,000. That's right, isn't it? Answer, that was the budgeted number of packs that the commercial team had put into what they predicted to sell that year. Question, what they predicted to sell. So what you were doing was going back, you were going to Auden to ask for 12,000 packs because you wanted at least to be able to sell the same number that you could sell with your own product. Yes? Answer, exactly. This is completely at odds with the initial suggestion put forward that a deal with Auden would make no sense to Mr. Baton because he would just enter the market independently and sell 40,000 packs a month, half the market. Counsel has put this case, and counsel then goes on immediately to draw out with the witness 2 vital implications. The first is that far from this being a bad deal for AMCO, it was on its face a terrible deal for the supplier, Auden. So if you go forward to page 543 in mine, 543 in mine, possibly 540 in yours, internal page 22.
Yep.
And look at line 15. The question from counsel, we're coming back to those things. On wanting to get the supply started, you say that was your main concern. And that was a concern, wasn't it? Because you had now negotiated were negotiating 12,000 packs on which to make a very large margin. And so a month is important, isn't it? It's worth quite a lot of money. Yes, of course, yes. You say at paragraph 84 of your witness statement, you can't speak on behalf of Auden in terms of why it was doing this. But I want to understand what you understood to be the consequence of the deal for Auden. And I think we established yesterday, you agree that if they had not sold the 12,000 packs to you, they would have sold them at market price to their own customers. Yes. So she confronts him with the point that this was essentially, on its face, an irrational commercial act by Auden. And second, the premise of the supply deal on this basis, to match the volume of sales that Mr. Baton could expect to get if he launches by himself with what the supply agreement would give, was that AMCO wouldn't enter the market with its own product. In other words, the very nub of the CMA's case. And if you go forward to page 546 in mine, which in yours will be internal page 25 or possibly page 543, but certainly internal page 25, and look at the question right at the end, line 19. The questioner says, you wanted 12,000 packs because you could get, you thought, 10,000 packs of sales of your own product. Answer, because Jane Hill, the commercial director, had put 10,000 in the budget. Mr. Patel was already selling us 6. I just took a punt and said 12. Over the page, she pursues this. The link with the 10,000 being you wanted to exceed, or at least match, make sure you could match what you would get if you went to market with your own product. Yes. So the premise for a negotiation like this, Mr. Baton, is if Auden agrees to supply AMCO won't enter the market with its own product. Yes, that is the premise of your negotiation. You're doing this instead of selling yourself. Answer, yes, but I'm not saying that to him. It's the case. Now,
we've then got the exchanges that we were referred to yesterday, leading to the answer on page 28.
Yes, the only comment on that is that his defence, I'm not saying that, would only matter if in law you have to show some express promise, which you might believe, but you don't.
Not on a wink point.
Not on the wink. What the counsel then goes on to say, as my Lord Justice Green says, straight away in a passage that we've now seen, is she hammers home with the witness precisely the implication of the supply deal is it's the alternative to competitive entry. And we've seen that, I won't take you in detail to it, it's on, in my copy, page 548, yours, least internal, page 27, begins at line 15, where the answer is there was definitely a bluff, because our position was extremely weak. He was very dominant. He had the whole market, rather inconsistent with the commercial rationale you've seen the tribunal articulate in its judgment. In hindsight, even at the time, I knew he didn't need to do this deal. It was a very risky situation for us. Question, you say it was a bluff. Come to that separately, yes, for sure. But you were telling him, if you did not do this supply deal, you'd come on the market and you contest 100%, which is what Mr. Clark is saying. Answer, I don't think I ever told him that, but clearly that was the implication of this. See before? That's the impression you sought to give him, that he thought we had a product that was about to be launched. Yes, when you spoke to him on these various calls, you would have been keen to give him that impression and so on. And ultimately, if you look at his answer at line 20, I won't go over this again, I suppose what we're really trying to do is give him the impression that you had some alternatives. Question, the alternative being you were launching your own product. Answer, yes, of course. Now, it is only after all of this has happened in the witness box that the President comes in the course of the cross-examination, with his own intervention, which he describes in the judgment as helpfully allowing the witness to set out his commercial rationale during the negotiations. It's after what we have now read. The President's intervention is very long. It begins in my copy, page 561, internal page 40, and I want to start, in the interests of time, top of page 564, internal page 43. And I'll just ask you to look.
561.
What is it?
Yeah.
561 in yours. So you see the President's question beginning at line 4. He says to Mr. Baton, after what we've now read, yesterday you said I thought it was very odd, but I didn't really inquire any further. My question to you is, why didn't you really give either Mr. McEwen or someone else an extremely hard time as the reason for what's on the face of it, an exceedingly one-sided transaction? And he says, well, yes. And overnight, as I've had a chance to think about this again, when we were in the process of acquiring Andifarm, Mr. Sully and I discussed this. We discussed a couple of arrangements that seemed to be a little bit odd. And he therefore says that it was then discussed. He is now talking about the time and how things stood when his business was originally acquiring Andifarm, which completed in late 2012, early 2013. So that's to situate it. The President is discussing with the witness that early period. You go to the next page, which is internal page 44, possibly in yours 562 of the bundle, mine 565, and you look in the middle at lines 10 to 16, he says there, actually, again, my thinking at the time would have been the thinking of any person, such as Mr. McEwen or Vijay Patel in his organisation, that there would be no point at all in having an agreement that allows us not to launch the product in return for 2 or 6 or even 12,000 packs when the market's 77,000. So I suppose that kind of logic gave me comfort. So standing back, what he's doing is explaining that his thinking at the time is there's an agreement not to launch the product independently in return for such low volumes under the supply agreement would be pointless, given how big the overall market was. And you see this because at line 23 at the bottom of that page, over to the top of the next, he observes that at this point, he says, lines 24, the orphan issue is not known to them. So just to situate this, his evidence about this is at a time before this thing that he earlier said was very risky and which he appreciated was not known. The witness then clarifies to the President directly, a little further on, that when he finds out about the skinny label issue, then the supply deal for 12,000 packs starts to look more attractive than launching his own product. And you see that on page 573 of yours, possibly, internal page 55.
55.
Internal page 55, begins at line 24 at the bottom. This is the witness's evidence. He says, I was at that point being constrained by them, and therefore the 12,000 seemed a little bit more attractive to me than even starting to look more attractive than launching my own product. President, I appreciate we're moving into the realms of what's for you and me speculation. Does that answer give us some insight into why this wasn't an odd or nonsensical bargain on the part of Auden? Answer, I guess at that stage it was starting to look more sensible for him, but the piece that's missing is there wasn't a commitment from me not to launch our product under any circumstances, and we for sure would have done. I never, even in the early days, I never said to him we would not launch. I never said it. And actually, this is the bit we saw before, apart from the threatening behaviour, there was definitely never a kind of quid pro quo that has been alleged by the CMA. There just was not. So the perspective of the witness on the commercial situation facing him here is manifest. It confirms the CMA's case, and in passing, he actually shows total awareness of the CMA's case, because he's implicitly seeking to rebut it in his final comment there. Stepping back, one of the most puzzling aspects of this is that it's not only what the witness actually said, which we've now gone through. The President at the time asked his questions to the witness on the footing that Mr. Baton could not enter the market and expect to get the 50% share. If you look back at page 571 in yours, possibly, internal page 53, and look at lines 12 to 21, there the President asks the witness, I entirely understand that if you had a product ready to go, if you were reaching an agreement to keep the product off the market,
Sorry, Mr.
line 12, the President,
Page
53 internally,
Yeah.
so the President is now putting a sort of hypothetical. He says, I entirely understand if you had a product ready to go, you were reaching an agreement to keep the product off the market, assuming all things equal, products are identical, in other words, delete orphan status, delete production problems, you've got something ready to go, the deal, and I know your answer to this question, but the deal would be 50-50, half the market, if you had a product to go. In other words, I will, Auden, provide you on this arrangement with 50% you stay out of the market. So what you see is that the witness is being asked about something which is, in the President's point, hypothetical. Forget all these problems. In those circumstances, is that what you would do? If you go over the page to 575, possibly 572 in yours, internal page 54, and look at lines 13 to 18 of the President's question. In other words, if you've got something ready to go, 50-50 is the likely rational outcome. But if you haven't got something ready to go, or if there are some kinds of problems, then actually the rational outcome is not 50-50, it's something less than that. So you see the President in the questioning seeming to appreciate that things have changed. And the basic premise of the H3 judgment, which we've now seen that there was a coherent commercial rationale put forward by the witness about how he was at the time of concluding the second written agreement, at odds with the CMA's case, which wasn't cross-examined on, is unfortunately totally incorrect. One further reference that I'm given, very helpful in my junior, page 56, which is internal page 574 or 577. You see the President's question beginning at line 20. In other words, he says to the witness, if I could put it in black and white, so it's on the transcript and you've got a chance to push back, the 2,000 or 6,000 or 12 increase in products supplied to you was a reflection of the bargained outcome. I appreciate you're going to deny this, was a reflection of the bargained outcome of how likely it was that you had the capacity to bring the product on the market and they wanted to buy you off. And then if you read through to line 10, you see that the President is appreciating here that in the circumstances, what is being haggled over is what's the right price to buy you off given the risk that you appreciate. And finally, after this intervention by the President, if there could have been any doubt, the CMA's counsel returns to drive the point home once the President is finished. The suggestion in the judgment is she did nothing after the intervention. That is impossible to understand.
Yeah.
If you go to, so it's page 659 in my copy of the transcript, internal page 138, possibly page 656.
But I mean, what's so puzzling about that passage at the bottom of 56, the top of 57, is that the President's actually putting the point, isn't he? Saying, you know, this is what the case is, that you're being, this is all about buying you off. I know you're going to deny it.
Yes.
So he realises in Mr. Baton's position is, oh, no, I never did that, apart from the threatening behaviour.
Yeah.
But, and yet, it said, well, this case was never put.
Yes.
I just don't understand that at all. Quite apart from your point that Mr. Dimitri had put the case. The President himself was putting the case.
Yes. That is the point, that by the time of the judgment, this appears to have...
Yeah. Sorry, you can take us to one...
The last reference.
1.3...
It's 138 internal.
Right.
It will be either 656 or 659 of the bundle number
Yeah.
for you. And here I'm addressing the point made in the judgment that the President makes a helpful intervention which clarifies the witness's evidence, which is that there's a commercial rationale. After that, the CMA's counsel does nothing, and she should have done. So if we look now on this page at line 11, this is counsel. Question. Yesterday you told the tribunal you thought the whole premise of the CMA's case didn't make sense because the economics were hugely in favour of Amco's new product. So let's just look at the transcript. Let's look at what you said. Looks at the transcript of his evidence. Well, why would I not launch a product as soon as I got access to 40,000 a month? So she records this, and then over the page, top, yes. But we can see, can we not, the trade-off in terms of volumes you're considering at the time, that you're deciding to conclude the supply agreement with Auden. It's not 40,000, is it? No. Answer. I think, as we discussed this morning, the orphan indication skewed the picture and certainly made it more interesting for us to do a deal for a smaller number of packs than 40,000 with Auden Mackenzie. She puts the point after the intervention again. And therefore I conclude it's not the CMA that has fundamentally failed in an aspect of due process. It is the tribunal that has misunderstood the nature of the case, the nature of the evidence, and the content of counsel's cross-examination. So I see the time. I'm going to turn rapidly to my submissions and say no more directly about the judgment of working through it. If you...
Well, he did set out in H3 large tracts of cross-examination, didn't he, the President?
Yes.
And I noticed at paragraph 102, he set out Mr. Baton's answer about the 40,000 packs. And again at paragraph 108.
My Lord, yes. Now, I asked about this too.
So did he not set out any of what you've shown us?
No. I asked about this myself, and it may be explained by the fact that at the time when these passages were being put at a hearing after the H2 judgment, the CMA's understanding is that the focus is on dishonesty rather than this point. Right? And yes, and these are the points, therefore, that were put forward and which are then played back in the H3 judgment. But what actually happens in the H3 judgment is you get this new reasoning about failure to put the commercial rationale you've come on the market with the 40,000 packs. And for that, had that been clear, we would have said, no, these are the parts of the cross-examination that are relevant to that.
But it should have been clear in the cat's mind because all of this was relevant to H2.
But if you go back to page 141, sorry, I'd go forward to page 141.
I'm sorry, is this in the...
This is in the cross-examination.
The cross-examination bundle, yes. Internal
This is Miss Dimitriou picking up after the President's intervention.
Yes.
And she puts at line 8, and the way for both sides to avoid each risk was to take the supply from Auden and not to enter independently, was it not? So you were taking a commercial view. It is risky to enter, so let us take the supply instead. Mr. Patel is doing the same from the other side of the table. Now, true it is Mr. Baton then prevaricates by saying, well, I can't say what was in Mr. Patel's mind. But in terms of was the CMA's case put to the witness, that's a pretty clear summary of what the case was, isn't it?
Yes, we say so, and that it's not alone.
Yeah, I mean, of course it's not alone, but I mean, that's another example.
Where did the cat actually say that in H3 that she hadn't cross-examined on any of these points after his intervention? Because if I recollect it correctly, he goes on at great length about not descending into the arena and how he'd asked a lot of neutral questions, perhaps not an entirely unbiased assessment of what they were. But where does he then say Ms. Dimitriou just left it all?
No, thank you for saying that, because I haven't put in my note what the reference is to that. I'm going
Okay,
to come,
well, you're
I'll come back to that if you may. But
Is it 121? That's when he
Yeah, I think
refers.
it's around about then, isn't it, really?
That doesn't quite cover it off.
no, I'll find it. There's a point where the tribunal finds that it makes the helpful intervention.
Well, it's 120, isn't it, where he says, Miss Demetriou Casey had the opportunity of asking further questions herself, so he recognises she did.
Yes.
However, although further questions were asked, none took the point here under consideration any
Yes,
further.
yes, I'm grateful. That is probably
Which is
the main
effectively
place.
the point you're making, isn't it?
Yes, I agree. There may be a later point too, and I'll try and find it over the short adjournment if it's not drawn to my attention. But yes, this was the perspective of the tribunal, that it asked the question, the council doesn't refer to it. I do believe that there is a later point at which he refers to this in the context of talking about the fundamental failure of due process. So I will then, if I may, turn to my submissions finally to draw. Yes, Mr. Jones points out that there's something further at 1214, top of page,
Yes, I'm just
internal
looking at
page
that.
80. The CMA at no time, second sentence, accepted Mr. Baton's version of events. To do so would be to concede that the decision was wrong and needed to be set aside. But it was not open to the CMA to decline to accept Mr. Baton's evidence and assert it was not to be believed until after he'd left the witness box. And we've now seen that is not what happened. So I'll turn then to draw the strands together by way of submission. And for this purpose, if we would open up our recent skeleton argument, which is at tab 9 of the core bundle. Page 261. On page 266 and following, we set out there the issues to be determined, and this reflects the agreed list of issues, but if it's open here I'm able to make certain comments on it by reference to the content of the statement of the skeleton argument. Issue 1, A, on page 266, what was the CMA's case and was it sufficiently particularised? Reference to the various parties' grounds and so on. Yes, the case was sufficiently particularised. I've shown you that the case was that there was an arrangement put in place under which Auden effectively paid AMCO to stay out of the market. I've shown you what it was based on: market context, the history of the 20 milligram agreement, same negotiators being involved when AMCO replaced Waymade, the contemporaneous evidence of negotiations, and fourthly, the conduct of AMCO after the negotiations had resulted in the deal. Without the need to go over it again, the CMA's case was a sufficient case for the Chapter 1 prohibition, without a doubt, and it was clearly put. Issue 1B, top of page 267 in my skeleton, did the CMA sufficiently challenge the advanced witnesses that the written agreements recorded the whole of the bargain, i.e. that there wasn't a common understanding that AMCO would not launch its own product? We've seen now the sustained cross-examination on this issue by CMA's counsel, and in my submission there can be no real doubt that the CMA's case about the common understanding, the premise of the supply deal, was properly put to the witness. And to draw these strands together, these points were put to Mr. Baton. Number one, in June 2014, AMCO believed its product was ready to launch, and it was forecasting to sell 10,000 packs. Number two, Mr. Baton preferred to take the money from Auden rather than the risks of competition entering with a skinny label product. Number 3, Mr. Baton used the threat of launching his own product as the lever, as leverage, including specifically his forecast internally of sales. He referred to 12,000 packs a month to secure the value transfers, to get the same number of packs from Auden as compensation. Number 4, in making his threat, Mr. Baton intended to convey he would launch his product if Auden didn't agree to his terms. Again, clearly put by Mr. Mitri. Number 5, Mr. Baton and Mr. Patel understood the premise of the negotiation was that if Auden didn't agree to the deal, AMCO would launch. He merely says, yes, that was the implication, but I did not say that. And finally, once the deal is done, the witness accepts. AMCO cancels future orders for its own product and suspends the project. So the common understanding that AMCO will refrain from independent entry in return for the monthly amounts is different from the written supply agreement, which provides for a 3-month notice period which can be triggered at any point. There's clear blue water between them. Issue 1C in the list of issues on page 267 of the bundle. Did the tribunal hold that the only evidential basis for the CMA's case was a value transfer? I've gone through this now today, and I've shown you the tribunal did adopt that position and that it was incontestably wrong. The position was somewhat different in the earlier judgment, where, for example, the tribunal did accept the importance of the background context and prayed it in aid as part of its reasoning for upholding the CMA's decision. But in the earlier judgment, it nonetheless did overlook or ignore the key contemporaneous documents all relied on in the decision, which were fully cross-examined on by counsel. Issue 1D. Did the CMA adequately put a case that AMCO agreed not to enter the market? The cross-examination by CMA's counsel was perfectly clear on this point. There was an understanding not to enter the market. The issue is that the case is put as a common understanding, a shared premise to underpin a written commercial contract. It has never been, as the tribunal seems to have thought, a case depending on the proposition that AMCO articulated a promise not to enter the market and then hid it by not making it a contractual term in the written agreement. Issue 1. Issue 1E, did the tribunal err by finding that the CMA had failed to cross-examine Mr. Baton properly on the commercial rationale? The reasons I've now developed orally plainly did err. The error was at the heart of the H3 judgment, and that is why it cannot stand. I'm sorry, yes. I have been given that missing reference that my Lord the Master Rolls asked me about. It's in paragraph 21.7 in H3. That's right, I will show you that now. That's the one I and I can only apologise.
21.7.
21.7 is on page 317. Yes, that's I'm sorry, that's what I had in my mind. Just under Roman 2. You'll see halfway down that page, not having cross-examined on these points and having declined to further cross-examine Mr. Baton after his answers, repudiating the CMA's case, were given. The CMA cannot look behind those answers and say they were untrue for reasons not put to him. So that is what I had in mind.
Well, that passage that I referred you to at page 141
Yes,
succinctly puts the case about collateral understanding, doesn't it?
it does. Yes, it's a finding that is wrong. last point, issue F, dishonesty. Should the CMA have put the issue of dishonesty to the witness, the advanced witnesses, Mr. Baton specifically? I've now explained that the CMA's case is not dependent on the existence of deception, dishonesty, or fraud, as the tribunal appears to have believed in the H2 judgment. And in any event, by the time we move to the H3 judgment, that point has reduced to a concern about putting to Mr. Baton that he was a liar in the witness box. The rest of dishonesty is now in the rear view mirror. There's plainly no need to go so far as to describe this as a case of dishonesty and put dishonesty allegations to the witness. The CMA's counsel put to the witness his account, his evidence, was not correct. She played the ball and not the man by accusing him of lying in court. There are many reasons, as we've now rehearsed, why a witness may, many years after the event, give evidence on which they're cross-examined and might not give an accurate account, which are consistent with the witness not being dishonest. And in our skeleton, paragraph 38 on page 277, 9 lines down, we refer to this and refer to some comments, speed I won't take you to the original, from the tribunal chaired by Mr. Justice Roth in an earlier case, the first pay for delay competition law trial in 2017. And in italics, he makes the point that it's familiar to this court. The witness may not be lying. This is not a case about fraud or dishonesty. There was no need to accuse the witness on that score. Back to the list of issues. Issue 2, jurisdiction. This was our case that the tribunal, under the conclusions section, said we uphold the CMA's decision and all the grounds of appeal fail. I've explained at the beginning of today that we're not now
You're putting it in a different way.
we're putting it in a different way. Okay. So I'll say no more about that. Next is issue 3. Did the tribunal err in H3 in setting aside the decision regarding the 10 milligram agreement in the period before the second written agreement? This is our third ground of appeal. And our point here is that even if there was this failure in relation to Mr. Baton, even if that was the case, it doesn't infect the earlier period when he wasn't the negotiator and when the negotiator wasn't called, and he was the only person able to speak to that.
I mean, you've made this point already. I mean, you say the background in H2 is perfectly clear, is absolutely relevant, and it's, when you got to the written agreement, it was already in place. So, if you're right about any of that will obviously stand up.
Yes, well, I think in view of that indication and in the interest of time, I'm not therefore going to develop it further at this stage.
Is there any big point you haven't made?
Well, the point made that I was going to develop specifically concerned the failure for the earlier period of the companies to put forward the chief negotiator, because at the trial...
You made that point.
Yes.
I mean, that's the failure to call Mr. McEwen.
Yes. Just to summarise the way that the battle lines
Mr. Patel and Mr. McEwen.
They say in relation to Mr. Patel there are particular reasons why we couldn't call him, and I'm not pursuing that. I am pursuing it.
There been some agreement with him?
There was some events that we're not going to pursue that.
Yeah.
Mr. McEwen, the only thing that was said was he'd left the company, but there was no reason not to call him. What then happens is, and this is procedurally quite an important point, so I'll spend just 2 minutes on it. There's then a debate about who should have called Mr. McEwen, if anyone, because the tribunal considers, and the companies submit, that in these circumstances it's the CMA who should call Mr. McEwen as the witness, not the company.
And you can't cross-examine him.
Yes. Now, if you step back, if you look at the nature of this sort of case in the tribunal, we say that's not the right approach, and it's quite a dangerous departure from what should be the right approach, because this is a jurisdiction where all of the documentary evidence and the interview transcripts, they are in their own right admissible evidence. And the CMA relies on all of that in the decision as discharging its burden of proof. Then,
That included interviews with Mr. McKeown.
that included, which I can take, that included incriminatory statements made by him contrary to interest by Mr. McKeown.
Yeah.
They're in the decision. Our point is that in those circumstances, the authority, and now I'm thinking more generally about a healthy system of enforcement of competition law, and why this point matters from the CMA's point.
Same point in insolvency, actually.
Yes, although I'm not as familiar
Well,
as
I mean, insolvency practitioners bring proceedings, and they have a problem as to who calls the witnesses, because they don't want to, because they want to cross-examine them.
Yes, now,
I mean, talking
here-
about the putatively bad people.
yes. So here, the position is that the CMA relies on a body of evidence. It includes the interview transcripts, and its case is that this discharges our burden of proof in the appeal. It's all admissible in the judicial tribunal. In those circumstances, the evidential burden is now on the companies. If they want to say that Mr. McKeown, their ex-employee, actually can say, no, the interview evidence is not correct, or a different gloss should be put on it, it really is they who should be calling that witness, and that the failure to call a witness in those circumstances can give rise to adverse inferences that the CMA can take advantage of. What I won't take up now showing you is that the CMA made this point, made it specifically before the trial opened in relation to Mr. McKeown, and said we will draw adverse, ask the tribunal to take an adverse inference based on his absence from the trial.
Yeah.
And the pushback was, no, it's if anyone, it's your responsibility to call this witness.
Pushback from the defendant
From-
or from the CAF?
From both, essentially. But the reasoning comes, or the submissions, because it's not reflected in a finding by the tribunal, I believe, to that effect. It's submissions
Yeah.
from the companies, is that that's how things should work. And on our side, we say, no, in principle, at that point, you should be able to draw adverse inferences. And you then move to a question of detail, which is this a proper case for the drawing of adverse inferences? So it's a second order question. At this point, the issue is, well, was there a real failure on the company's part? And in their cases today, their point is, no, because you had Mr. Baton and Mr. Sully there, and they could speak to this. And what I was going to show you was that both of those, in different ways, say, I was in post at the time, so Mr. Baton was actually at the company before he took over the negotiations. But when asked about this in cross-examination by Mr. Mitriou, he says, I didn't discuss with him the origin of the deal. Mr. Sully, in his cross-examination, also says to Mr. Mitriou, I didn't know about this either. And that is why the CMA is perfectly entitled to say at the closing of the trial, this is, in the context, a case for adverse inferences to be drawn. That's how we put that one. And I shan't develop it further, but that is how we see the point.
Well, the critical point there is Mr. Baton and Mr. Sully's evidence was that they'd never discussed it with Mr. McKeown.
Yes.
The only person who could give evidence as to whether or not there was a common understanding going back to 2012, or to refute it if that's what the case was Mr. McKeown.
Yes. Mr. Baton says in terms that I didn't discuss it with him. Mr. Sully, questioning, says I essentially didn't talk about things on this level with him. So that is why we say it's a real point. And from the point of view of the authority for cases generally, we see this as a significant point for future cases. If it pleases the court, those are my submissions, and I'm grateful for your indulgence. I'm sorry for having taken up so much time.
Hello? Any more? Julian?
No.
All right. Just
Thank you.
form, Mr. Tanner. It's customary to ask my colleagues if they want to ask any other questions.
Very
thank you
shy
very
to
much.
ask the question.
Something we hadn't already thrown
Well,
at
and if I may then also follow from, if anyone wishes to follow me, no. We're done.
Well, we do encourage
Yes.
juniors to follow in this court, and we haven't put you to your election because we normally expect them to do so. I understand Professor Bailey is going to
Professor
speak.
Bailey's going to. So.
He is. He's going to be dealing with the other
For
side's
future
case.
reference, I know this is a big case, and I know everybody's got a lot riding on it, and I know the time is short, but we do expect to see juniors making submissions in all cases. Thank you, Mr. Tanner. Who's going next? Mr. Brealey.
So I'm swimming upstream, but I hopefully
You can't ask your junior to speak because you haven't got one.
no. But I'm ably assisted by Maldeners. I'll come back to Mr. McEwen after lunch. There were detailed submissions on that.
Yes, you want to poison our minds properly first.
Well, about poison, but if I go to the list of issues, just to flag what I'm going to deal with, and that's at core bundle page 4. Because we've tried to
Yes.
divvy it up. I'm going to deal with issue 1B, second sentence.
Hang on. Issue 1B, second sentence?
Yeah. There's two parts to. So issue 1B is written agreements. Did the CMA sufficiently put its case on the nature of the alleged 10-nig agreement to advance witnesses? So that's a CMA's case in the decision. Mr. O'Donoghue is going to deal with that. I'm going to deal with the linked but separate point. Did the CMA sufficiently challenge the advanced witnesses' evidence that the written agreements recorded the whole bargain between advance and Auden?
Right.
That was a very important factual issue to be determined by the tribunal. Did the written agreements record the whole bargain? So that's issue 1B. I'm going to deal with that. I'm also going to deal with issue 1E, commercial rationale. Did the CAT err in H3 in finding that CMA had failed properly to cross-examine Mr. Baton on the commercial rationale behind AMCO's purported intention to enter the market? And we say that the tribunal did not err. And again, I've heard what Mr. Turner has said and the questions to him from my lords.
Mr. Brealey, you might just have to speak up a bit.
Yes,
Not that I can't hear
I
you.
beg your
but
pardon.
you're-
So it is very important to understand that the way that the evidence has been portrayed on this commercial rationale is incorrect. And essentially, what happens is that both the CAT in H2 and the CMA work backwards.
Sorry?
Work backwards.
Yeah.
They take the second agreement and the facts relating to the second agreement and say, there you go, that's what it was in October 2012. And what I want to do is show the court the evidence relating to the start of the infringement, the alleged infringement. It's very, very important to distinguish between two periods, which the CMA actually does. The start of the infringement in October 2012 through 13, beginning of 2014, and then we get to June 2014.
But you said they take the second agreement and say that was it in October 2012.
Correct.
I see. So that you say that they impose the second agreement on the original position.
Correct. And the tribunal does that in H2, and so does Mr. Turner with the greatest respect. And so did the CMA at trial.
Right.
Wrongly.
Well, it is wrong because the facts are completely different.
Right.
I will also deal with issue 1F, the issue of dishonesty. We say there was a case advanced in the decision concerning dishonesty. Mr. Turner did not refer to paragraph 10.113, 115, which we say clearly shows the CMA alleging that advanced
10.113
3 and 10.115 from memory. I think that's right. Summarising it.
You couldn't just give us the page number for that.
Sorry, is that the judgment or the decision?
The decision.
The decision.
So,
1226.
yes, it's this, well, yeah, we go to 1219, and we will look at this advice when I come to the written agreements. So 1219, this is in section 10, where the CMA is saying there was an intentional breach. And that is why the tribunal in H2 and H3 refers to intentional breach, because in this section the CMA is saying that Advance was
So
guilty.
which paragraph are you referring us
Well,
to?
I'm looking at 1038 at 1219.
Well, page number's completely awry.
1083, do you mean?
1083, 1219.
1083 is page 1219. 6th of June communication with Mr. Sully. Is that the one you want?
That's it, yes.
Okay.
So this
So-
is in the section on penalties,
This is a section on penalties,
which is about intention.
which is about intention,
Yeah.
but the company is being fined for an intentional breach. And there is references.
Hang on, 1083 is recording a memo from an associate in the competition law team at Pinson Mason,
Yes.
recording a conference call between AMCO and Auden to
Yes.
negotiate the written agreement. So where does it say there that
Well,
this was dishonest?
I will. Well, I'm going to come to this, but I just wanted to put this in context.
Right.
So this is advice, and if one just goes over the page, I'll have to get my page number right.
Yeah, 1084.
Auden would be considered competitors, hence my presence on the call as a safeguard. Now we're going to look at this because we haven't seen this note of a conference call, but Pinson Masons were revising on a conference call, hence my presence as a call on as a safeguard. And we're going to look at the note because it is very relevant to one of the issues. If one then goes to the conclusion,
Which is 10113.
10113,
Yeah.
here is the CMA saying, Pinson Mason's advice was not provided on the basis of a full an accurate understanding of the facts as AMCO understood them. That's 10.113. It gives two reasons. The first reason at 114 is that AMCO basically misrepresented that they were not competitors. Vincent Masons were advising as to whether there was a risk of potential competition. Hence, that's why there was a safeguard on the call. Yes. And then at 10.115, yes, this is why we sometimes hear the CMA's submissions and they just do not ring true. Secondly, it is said, AMCO did not disclose to Vincent Masons, to get the full extent of the negotiations with Auden, did not disclose the common understanding on the basis of which it was operating and which it was about to renew when it received the 6th June 2014 advice. Now, the company, Mr. Sully, the General Counsel, who is involved in this, Mr. Baton, the tribunal, have understood that the CMA was indeed alleging that there was a separate common understanding, and when they asked Vincent Masons to advise on competition law compliance, the relevant individuals, that can only really be Mr. Baton and Mr. Sully, failed to disclose the side agreement, or whatever you want to call it, the common understanding, the market sharing agreement, to the solicitors. Mm-hmm. Now that, we say, is an allegation of serious misconduct, that you are seeking advice from the solicitors, and we'll see the 6th of June.
What's the legal duty to disclose the facts to your solicitors? I thought it was pretty common for clients to come in and tell their solicitors part of the facts. Then you discover on the last day of the trial.
And we told the full story.
The full story. When the suitcase, I did a case once where the suitcase arrived with all the documents that had not been disclosed by my client on day 35 of the trial. The case was settled on the same day.
My case is the lock-up garage in King's Cross, where the genuine documents in relation to the sinking of the ship turned up.
I think with respect, it goes further than that. On the 6th of June, there was a conference call.
Yeah.
And the company asked the solicitors to advise on the second written agreement to ensure that it was competition law compliant. And the solicitors recorded the terms that were agreed on the conference call. So on the conference call was Auden's external solicitors, and Advance's external solicitors, General Counsel and Mr. Baton. And on the call...
Sorry, who was on the call? Auden?
Auden's external solicitors.
Well, have we got a copy? Have we got the...
Yeah.
I think it would be helpful to see the document, really,
yes,
and who was there.
Okay.
Auden's external solicitors who were?
No.
Sorry.
Well,
Chancellor.
yeah. Come.
GJR law.
Yeah. Well, if we go to the unagreed supplemental bundle, and maybe we can just look at this before we rise. Tab 56. Page. It starts at 1900, but it's 1899. I hope that's the right number. 1899.
Do you know which volume that's in?
Yes, that is Unagreed Supplemental Bundle, Volume 3. This all goes to the issue, did the second agreement record the whole bargain? It also relates to dishonesty, But we make a prior point. The witnesses were saying, we took legal advice, we covered ourselves because we involved the solicitors. And that is one of the themes that the tribunal accepts. And we'll come on to that.
Does this go to infringement or simply to penalties? Under section 36(3), this had to be addressed. I'm not certain the tribunal's got round to penalties yet, has it?
I'm not talking about penalties with respect. I'm talking about whether there was an unlawful common understanding that was not recorded in the second written agreement. Because the tribunal said there is a key issue here. The witnesses are saying the second written agreement recorded all the terms, including clause 2.2, the non-compete, and we'll have a look at the agreement. And that's what Baton, the CEO, and Sully, the General Counsel, were saying. There was no unlawful common understanding. Everything that we agreed with Auden was set out in the second written agreement. And one of the contemporaneous documents that shows that is this document. Because Mr. Baton said...
Let's look at it in terms
Yes.
of,
So this is from a solicitor at Pinson Masons. So if we look at the top of 1899, and this is to Robert Sully, the General Counsel. Subject, attendance note, privileged and confidential. So, hi Rob, it was very nice to meet you earlier today. I thought it would be helpful to formally record my attendance at your offices and on the conference call during the discussion with Auden Mackenzie in respect of an own label supply agreement for 10 mg hydrocortisone. Also present on the call were Rob Sully, that's Advance, John Baton, Amit Patel, Auden, and Charlie Drone, that's JGR Law, that's Auden's external solicitors. The purpose of the call was to discuss the entering into of the above own label supply agreement and a number of the key commercial terms. So this is supporting Mr. Baton's unchallenged evidence that he wanted the external solicitors to record the terms. Of key concern for AMCO was Auden's ability to prevent AMCO from launching its own 10 mg hydrocortisone and ensuring continuity of supply for AMCO's customers once it entered into the agreement. Prior to the call, I discussed with you the extent to which AMCO would be considered a competitor. And she goes on to talk about the orphan designation. She refers to the orphan designation as akin to an IP right. And from a competition law perspective, in respect of this product, the orphan indication AMCO and Auden would not be considered competitors whilst the orphan designation was in place.
well, that's decided by the Tribunal de Bureau.
Although there were many economists.
Is it appealed?
Yes, well, that's part of my object infringement.
Right, that's part of
The tribunal on H2 did not. That is a red herring for what I'm talking about now.
Well, it's not a red herring because this is the complete substratum of this advice.
What I really want to emphasise is not the advice as to whether they were potential competitors. The tribunal, we say, got it wrong. We had economists which said this was wrong. What is really important is that because there was a risk of potential competition, hence my presence on the call as a safeguard. Now, and then we'll rise. The next bit is really, really important. As a result, the orphan designation has decided the best commercial option is to source supply from Auden, whose product is capable of being marketed for adrenal insufficiency. That's the adults version. Now, the following terms were agreed in principle. So on the call, with all the lawyers present and Mr. Baton, Mr. Sully and Mr. Patel, these terms were agreed. The template for the agreement would be the previous agreement, subject to the following changes: 2-year duration. AMCO would source exclusively from Auden for this period into the territory. AMCO could not be stopped from developing its own hydrocortisone. However, if AMCO were to launch its own product, it would provide Auden with at least 3 months' notice of its intention to do so, at which Auden would have the opportunity to serve notice of contract termination. A reciprocal period of 3 months' notice was discussed but was not agreed. AMCO would have a minimum of 12,000 packs. And then over the page at 1900, it was agreed that Rob Sully, the General Counsel, would circulate the amended agreement and that Rob and Charles Duran would finalise the terms. And we'll see another document and we'll see the cross-examination on this. But as I say, Mr. Baton's evidence was that he instructed external solicitors, Pinsent Masons, to record the terms that were agreed with Auden, and this supports his evidence that he gave that there was no unwritten common understanding. The written agreement recorded the whole bargain. And when we see the cross-examination, we will see that he was never challenged on this. Mr. O'Donoghue says, the solicitor says, please let me know if there's anything which I've missed or is not as you'll recollect, which confirms, advances evidence to the tribunal that the written agreement recorded the whole bargain. The advanced witnesses were not challenged on this, and as we shall see, the tribunal, in the light of this document and the unchallenged evidence, concludes that the witnesses did, in fact, cover themselves.
So where is this referred to in H2 and H3, this memo?
I will take you to the cross-examination.
No, in the judgments. Just for my note.
Yes, I'll have to.
Could you give me that at 2 o'clock?
Yeah, I'm not sure. It is.
All right, we'll sit again at 2:05.
Oh, Abel.